Supreme Court won't immediately settle Trump immunity claim. Let's get to that breaking news. Everybody, we have got this. It's from the Supreme Court, where Special Counsel Jack Smith's request to immediately settle Donald Trump's immunity claim in the election interference probe, IT has been denied. Essential shuttling that which Jack Smith wanted, the fast track, if you will, to decide presidential immunity. Donald Trump, of course, has asked the Supreme Court to take this case up as well. So there's a lot to get to right now because the interpretation of this could greatly sideline upcoming cases and potentially affect the 2024 election. Joining us now, we have NBC Justice and Intelligence correspondent Ken Delanian, and attorney and U.S. legal analyst Barbara McWade. What's your interpretation of this? How much does this set back Jack Smith? This is definitely a setback for Jack Smith. WHO had hoped to leapfrog the Court of Appeals and go straight to the Supreme Court. He will have to first litigate the matter in the D.C. Circuit Court of Appeals. In the meantime, since he filed this request with the Supreme Court, the D.C. Circuit said they would hear the question on an expedited basis. They have set oral argument in the case for January 9th. If they decide fairly quickly, then we could be back at the Supreme Court maybe in a month or so. If the court acts quickly, it could be that they take their time and we don't decide the case until June, in which case, the trial will be delayed by that amount. I think the March 4th trial date is in some trouble now. That doesn't mean IT could be tried before the election. We're looking more at a summer trial instead of a spring trial, which potentially affects the elector. Barbara, how long would a trial like this take? I have assumed IT would take about 2 months. There are 5 different scabs here, each of which would take the government a week to try, and then make a week for closing arguments and deliberations. I think at the closest, 8 weeks. You're right, the primaries will have been settled likely by June. The conventions will be beginning in August, and so this would have to occur kind of simultaneously with a lot of campaign activity. Ken, presidential immunity was bantered about on 2 tracks legally. With regard to the U.S. District Court of Appeals, January 9th, being when that particular case goes and gets decided, or at least begins with the oral arguments, give me a sense of how this potentially affects that, if at all. Is that completely separate, or can there be influence in some way here? Well, there's 2 arguments about immunity going on. One is in civil cases where Donald Trump is being sued, for example, by Capitol Police officers over January 6. The appeals court, the D.C. Circuit, has ruled that he is not subject to presidential immunity because he was not acting as the president. And that was an important ruling because IT interpreted the same conduct that the Court of Appeals is now going to have to interpret in the criminal context, and potentially the Supreme Court. And what the judges found is that the things that Donald Trump was doing to try to overturn the election, calling local officials, getting his lawyers to file lawsuits, a scam to create false electors, none of that had anything to do with the role of president. The President of the United States does not have an official or statutory role in state-by-state elections to elect the president. He was acting as a candidate and a politician, and not as the president. That may be relevant for what the Court of Appeals has to decide here, and ultimately the Supreme Court. They may not have to get to the question of whether a sitting president, now former president, can be charged for presidential acts while in office, because they may decide that what this was not presidential acts. And right now, there's a doctrine. The Supreme Court has ruled that a president is immune from civil lawsuits while in office, but has never ruled on the question of whether a president can be prosecuted. The Justice Department does have a long-standing legal opinion that a president can be indicted or prosecuted or tried while in office. Alex. But then again, no president has actually been accused of doing the things that this particular one, which is why this is also first time and really not tried in the courts before. Let me read something. That was the argument that Jack Smith made, and he said in asking the court on an expedited basis to do so, IT presents a fundamental question at the heart of our democracy, that being whether a former president is immune from federal prosecution for crimes committed while in office. People were heralding doubting move by Jack Smith as being kind of brilliant. As it turns out, IT has not worked for him. Is IT something that was a very risky move, or is IT something that should have duly been tried because of the unprecedented nature of what we're dealing with big picture?